Ripple XRP lawsuit referred to magistrate judge for settlement. Due to Judge Hamilton's distraction with Judge Torres' decision regarding XRP programmatic sales, the Ripple XRP lawsuit was referred to a magistrate judge for settlement. After partially granting and partially denying the defendant's petition for summary judgment in Zakhanov versus Ripple lawsuit, a U.S. District Court judge sent the case to a magistrate judge for settlement. As XRP programmatic sales were ruled not to be securities by the SDNY court, the judge's decision sparked heated controversy among the XRP community. A settlement is being negotiated in the Ripple class action lawsuit. In the class action lawsuit that included Ripple, XRP, and CEO Brad Garlinghouse as defendants, Judge Phyllis Hamilton of the District Court for the Northern District of California rendered a ruling. On the class actions filed in federal and state courts, the judge granted the defendant's motion for summary judgment. According to CoinApe's reporting, California law denies defendants summary judgment on plaintiff Sostak's individual claim. The court also ruled that the arguments put up by Ripple and plaintiff to exclude the testimony of Stephen P. Feinstein, S.P. Kothari, and M. Laurentius were both dismissed as irrelevant. Magistrate Judge Robert Illman was appointed to mediate the parties' dispute in the Ripple case by further order of Judge Phyllis Hamilton. Investors did depend on Ripple's endeavors for earnings, according to Judge Hamilton, who disagreed with ESDNY Judge Torres' summary ruling on XRP programmatic sales. The XRP army is wondering what Judge Hamilton's judgment, which ignores Judge Torres' ruling, would mean for the Ripple versus SEC lawsuit, which has stoked worries over whether or not XRP is a security. According to Mark Fagel, a former SEC lawyer, Ripple's main worry is that the SEC would use this case out of California in the Second Circuit to challenge Judge Torres' summary decision on XRP before addressing the fraud allegation. However, the court must determine if XRP sales were considered securities. The lawsuit might not have wider ramifications, even if Ripple loses, according to Fagel and ProXRP Bill Morgan. All the information presented in this video is derived from the data provided by CoinMarketCap. To stay up to date on all the latest XRP news and cryptocurrency news in general, make sure to subscribe to my channel and give it a like. Examine this now. Settlement of the Ripple litigation has been referred to the magistrate judge. Judgment in the Zakhanov v. Ripple case was mixed when the defendant's request for summary judgment was considered. A judge in the D.C. Federal District Court then sent the matter to a magistrate judge for a possible settlement. The judge further stoked tensions within the XRP community by ignoring a lower court's ruling that XRP programmatic sales are not securities. Judge Phyllis Hamilton of the Northern District of California's District Court delivered an order in the Ripple class action lawsuit, which involved a settlement motion. Also, the plaintiff's petition to exclude Spee's testimony rendered irrelevant the attempt by Ripple to exclude Spee's testimony, which is worth noting separately. It was likewise deemed irrelevant to consider Kothari and M. Laurentius. And supplementary order was made by Judge Phyllis Hamilton, requesting that the Ripple matter be sent to Magistrate Judge Robert Illman for resolution. Judge Torres of the Southern District of New York handed down a summary judgment on the XRP program, but Judge Hamilton had different ideas. Investor others, he said, could and did put their money on Ripple's shoulders. Following Judge Hamilton's decision to remove Judge Torres from the case, XRP supporters are wondering how this development would affect Ripple and the SEC's ongoing dispute over whether or not XRP is a security. According to Mark Fagel, a former SEC attorney, the biggest threat to Ripple is the chance that the SEC may use this California case to appeal Judge Torres' summary decision on XRP to the Second Circuit. But before the court can decide on fraud, it has to decide if XRP sales were securities. Even if Ripple is determined to have broken the law, the case might not have far-reaching consequences, as pointed out by Bill Morgan and Bagel, who are in favor of XRP. Just recently, Ripple and the SEC's conflict heated up. The Northern District of California United States District Court has rejected a number of key claims contained in a class action lawsuit against Ripple. The corporation won a procedural win because of this. The bulk of the class action complaints leveled against Ripple in the U.S. were dropped when Judge Phyllis Hamilton granted Ripple's motion for summary judgment on federal class liabilities for unregistered and state law securities claims. Stuart Alderete, chief legal officer of Ripple, expressed his satisfaction with the termination judgment. The jury will assess the security status of XRP The court did not decide whether XRP constitutes a security, notwithstanding the dismissals. A jury will have to decide if XRP passes the Howey test, which is a major need in this case. Also, a California judge has opted to try Brad Garlinghouse, CEO of Ripple, for civil securities fraud. In 2017, the lawsuit claims Garlinghouse made fraudulent statements about the sales of XRP. Unlike Ripple's limited success in New York, the trial will focus on whether Garlinghouse's actions impacted investors' decisions, according to the United States District Court for the Northern District of California. This ruling came after the court rejected 4 separate petitions. The goal of this trial is to determine by a split jury whether XRP should be considered a security under the law. In the Southern District of New York, Judge Analisa Torres' finding differs with Judge Hamilton's conclusion. Given the little amount of money at stake and the likelihood of a jury finding against Ripple, Judge Torres ruled that XRP did not meet the requirements to be classified as a security when offered to retail investors. Fred Rispoli, a legal analyst, brought up the fact that a settlement could be reached in the California case. Both parties were granted until July 8, 2024 to make a move that was limited to seal a single exhibit, and there are imminent deadlines and motions to consider that need them to reconsider their request to seal portions of their pleadings. The court will thereafter issue its final decision regarding these motions. A disaster could happen, but the SEC could also pull off a last-ditch spectacular victory in the Second Circuit. Judge Analisa Torres' divided decision in July 2023 sparked that while she found that selling XRP tokens to regular consumers does not constitute a sale of securities. She found that Ripple was in violation when it dealt with institutional investors. This decision has muddied the waters of Bitcoin regulation while also giving each side a victory. Christina Lipman, a former SEC employee, hinted in May 2024 that the agency might not look into the matter further. Contrast this with other recent court decisions, including as Judge Jed Rakoff's decision in the Terraform Labs case, which rejected identical grounds. While Ripple is attempting to reduce the projected $2 billion in fines, Hogan is claiming that investors could lose out if Ripple is forced to sell a lot of XRP due to the severity of the penalty. The SEC was established to safeguard exactly which group. Jeremy Hogan, an XRP supporting attorney, recently posted on XRP about his skepticism that the U.S. Securities and Exchange Commission will ever emerge victorious from the protracted legal battle it is engaging in with Ripple. The lawsuit is now en route to the U.S. Court of Appeals for the Second Circuit, but even if the SEC wins, the outcome might still not be in their favor. According to Hogan, SEC will face significant difficulties in the Ripple appeal. The Securities and Exchange Commission may face challenges in appealing, even though a victory is possible due to the complexity of the case. The matter will most likely be remanded to the trial court for further factual assessments. Here we see an example of a situation where the SEC's initial success could lead to protracted legal proceedings. A district court ruling from July 2023 by Judge Analisa Torres led to this situation. The judge ruled that the sale of XRP tokens to retail investors through exchanges does not constitute the sale of securities. That's all for now.